And I have an amendment at the desk and ask unanimous consent to waive the reading.
Without objection, the reading of the amendments dispensed with, and Dr. Harris is recognized to present his amendment.
Thank you very much. Mr. Chairman, what this amendment does, it actually combines several proposed amendments. It's an amendment that on issues that we've dealt with before in the committee. One of the parts of it exempts the H-2B workers that received visas in the past 5 fiscal years from the statutory cap. So this removes the H-2B employers who are what are called certified employers. That is, they've followed the rules. They're certified by the department as being an H-2B employer. This removes the uncertainty they face every year with the lottery system, which picks winners and losers. So what it does says you're a certified employer, you can have the same number of employees, you can have the same number of H-2B workers in a given year that you've had in the past 5 fiscal years. It also incorporates Mr. Newhouse's proposals from the past that expand H-2A temporary agriculture worker visa seasonality. It includes an amendment that prohibits funding to modernize the H-2 program requirements, oversights, and workers' protection rules just to make it easier to find H-2 workers. And it has the last part of it is one by Mr. Edwards and Molinar that allows the admission of temporary circus and carnival workers under the P-visa system. So what it does, it takes a lot of the temporary worker issues that we've had and deals with them. Why do we need to do this now? Because, as the administration attempts to remove people who are here illegally, illegal immigrants, it would allow some of those positions to functionally be replaced by people who are here under temporary work visas, not to be confused with illegal immigration, these temporary work visas, and provide some certainty to employers who, again, in all these programs, they have to attempt to seek American employees first. They have to pay the wages that you would pay to an American employee, and if you can't find one, then you'd be eligible to have this temporary foreign worker here. I think it's the right time to make these definitive changes to those temporary worker programs to aid our employers who, again, are going through, some of whom go through a difficult time because of the removal of some of the millions of people admitted in the last 4 years and who are being removed. So with that, I would urge support of the en bloc amendment.
Thank the gentleman. Chairman Amodei is recognized to address the Harris en bloc amendment.
Thank you, Mr. Chairman. I appreciate the gentleman's amendment, and I thank him for his willingness to include Mr. Newhouse's and Mr. Edwards' positions in his bipartisan en bloc amendment. I support the general ideas behind some of these amendments in the en bloc, and I know that we take similar amendments every year on a bipartisan basis. I'm not suggesting that we do anything else. I do recommend we approve his amendment. However, changes to visa policy are just that, policy changes that should be worked with Chairman Jordan and the authorizing committee. This committee's jurisdiction over such policy changes, especially ones that change the Immigration Nationality Act, is probably not present. But if we don't support these to drive the conversation with the folks in the policy area, then what the heck? And so, while I have the utmost respect for the chairman of the Judiciary Committee, it's time that they come out of the weeds and weigh in on this so that we have to stop tiptoeing around the edges of what our jurisdiction is. I encourage your bipartisan, nationwide support.
Thank you, gentlemen. Gentlelady from Illinois, Ms. Underwood, is recognized to address the Harris en bloc amendment.
Thank you, Mr. Chairman. This amendment requires an expansion of the H-2B visa cap based on overall demand in the last 5 years. It expands the H-2A agricultural work visa by broadening the definition of agricultural labor. It prohibits funding to modernize H-2 program requirements, oversight, and worker protections rule, and it expands the use of P visas to circus carnival workers. I understand that each of our districts may have unique needs as it relates to these various programs covered by this bipartisan en bloc amendment, and I appreciate our colleagues working together across the aisle to offer it. I plan to support the amendment, and I yield back.
Thank the gentlelady. Do any other members seek recognition to speak on the en bloc amendment? Gentleman from North Carolina, Mr. Edwards, recognized.
Thank you, Mr. Chair. Members, in Western North Carolina, our local businesses, farms, and community traditions don't just define our economy, they define who we are. They're family-run, hardworking, and deeply rooted in the values of self-reliance and service. But these pillars of our district are being threatened, not by regulation or global markets, but by something as simple and fixable as labor certainty. That's why this visa en bloc is so important. This en bloc is a series of thoughtful, narrowly tailored amendments that offer practical solutions to support American workers and small businesses without expanding immigration, all while strengthening our rural way of life. Let's start with Congressman Harris's Certified Seasonal Employers Amendment, which addresses a growing crisis for small seasonal employers. These are businesses that follow every rule. They hire American workers first, paying prevailing wages, and meet every federal requirement. But due to overwhelming demand and outdated visa lottery system, many are being shut out of the H-2B program year after year. This amendment gives a lifeline to those who've demonstrated 5 consecutive years of full compliance by guaranteeing a set number of returning visas. This doesn't just help those employers, it helps every other small business that faces labor uncertainty because it's trying to use the overprescribed H-2B program and it supports their communities. These are people who sponsor Little League teams, serve on local boards, and keep our small towns alive. We owe it to them to reward reliability and integrity with a stable, predictable process. Congressman Newhouse's H-2A seasonality amendment is equally important. This is a vital fix for our agriculture producers. In NC 11, farming means high-value specialty crops, including apples, tomatoes, vegetables, and your Christmas tree. These crops don't grow on the same schedule, and yet our visa rules treat them as if they do. Right now, when the apple harvest ends in Henderson County, those visa workers must leave, even if nearby growers still need them to plant or harvest. That makes 0 sense. This amendment gives the agriculture industry the flexibility needed to retain skilled and legal seasonal laborers across crop cycles and across employers for up to 12 months. It's not an expansion of the program, it's just a smarter use of the workers that we already have. Lastly, we need to address a unique but equally critical workforce need faced by our county fairs, agricultural shows, and festivals. These are more than events. They're cornerstones of our communities, supporting FFA chapters, 4-H clubs, and local charities. But the carnivals and mobile entertainment companies that make these possible are struggling with an unsustainable labor shortage. That's why I'm leading an amendment to transition approximately 10,000 carnival workers from the overstretched H-2B program into the more appropriate P visa category, originally designed for traveling performers and entertainment professionals. This simple fix preserves a cherished part of our all-American culture while freeing up thousands of H-2B slots for other employers, including farmers, landscapers, and foresters, each of which are also desperate for relief. Together, these amendments deliver targeted, conservative solutions that reflect the needs and values of Western North Carolina. They protect local jobs, reward good actors, and help stabilize the seasonal workforce that we so desperately need. I urge the adoption of this en bloc amendment, and I yield back.
Thank the gentleman. The gentleman from Georgia, Mr. Bishop, is recognized to address the en bloc amendment.
Thank you very much, Mr. Chairman. I rise in support of this bipartisan en bloc amendment. While I continue to oppose the underlying bill, the amendment would help provide more workforce certainty to seasonal employees and agricultural producers and preserve markets for consumers. Right now, America's farmers and foresters are having a hard time getting the workers they need to bring their goods to market. Our food supply chain is a matter of national security, and forestry products are essential in every American household, whether it be wood, paper, or pulp. Adoption of the amendment will allow for year-round H-2A workers, as well as cut red tape and onerous reporting requirements for employers who have followed the rules and who demonstrate a strong need for temporary foreign workers. I support this amendment to help bring more certainty to America's seasonal employers and agricultural producers, and in turn, to American consumers. Passage of the amendment, however, will not be enough to overcome my opposition to the underlying bill. But I think it's a good amendment. I think it's good for American agriculture and good for American consumers. I thank you, and with that, I yield back.
Thank the gentleman. The gentleman from Texas, Mr. Cuellar, is recognized for his remarks on the en bloc amendment.
Chairman, thank you so much, and again to the chairman of the subcommittee and the ranking member and the co-sponsors and the lead person, Dr. Harris, and the other members that are co-sponsors. And Shelley, also, I know you and I have been talking about this for a long time. Look, members, every single member in this room knows that either you know somebody that is affected by the H-2B, H-2A, or the P visas for the circus or carnival. Everybody in this room, you know it does. As we are seeing our economy, there are certain jobs that Americans don't want to do. And I'll say first, give those jobs to the Americans, any American worker that wants to do that. But if we can't find that, then we got to work with the H-2B, H-2A, and the P visas for the circus and carnival workers. Certainly, the H-2B amendment, it's a bipartisan support that works on the past 5 years, as it was mentioned on the statutory. We're not expanding this. We're using this in a very smart way, efficient way to address the needs that we have. So certainly the ability to hire H-2B visas when workers, American workers, are not available makes sense. And again, it's to make sure that we address, because most of this are small, hardworking individuals, businesses that we need to address. So H-2B, seasonal businesses play a very significant role in our nation's economy, and we need to make sure that we help them so they can continue contributing to our economy. And again, the H-2A amendment, the temporary agricultural worker, to make sure that we address that. And I know we're going to go with another amendment that I think Mr. Valera is going to offer and amend the parole for the agriculture. I support that also. But again, we know in the agriculture area, we need workers there. My father, my mother were workers in the ag, and it's hard. You know, anybody that wants to go out there work in the hot fields, it's very, 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 very hard. And again, if you don't have an American worker, you gotta find somebody that can do this. So this is, again, important. And finally, the P visa, the temporary circus and carnival workers, you know, again, name any place of the country and you will have that. San Antonio, I've seen that. Laredo, WBCA, we've seen that. Name any place and you will see the circus or the carnival workers, and we got to help those. So again, give those jobs to Americans, but some of those jobs are hard, and if we can, we got to find this solution. So to all the co-sponsors of this bipartisan folks that have been working on this for many years, Mr. Chairman, I ask that we support this bipartisan amendment.
Thank the gentleman. Now recognize the gentleman from Washington, Mr. Newhouse, for his remarks on the en bloc amendment.
Thank you, Mr. Chairman. I just want to appreciate the hard work of the chairman of the subcommittee, Mr. Amadei, as well as the ranking member. I also want to point out the hard work that Dr. Harris has been providing in this effort to truly make some important changes in our immigrant work visa programs. So thank you very much for that. And this, as you have heard from several speakers, these are bipartisan efforts. Many people recognize the importance of having an immigrant workforce, but I want to underscore we want a legal immigrant workforce, and these changes work towards that end. So this en bloc includes two important provisions that I have proposed, and I'll just briefly talk about those. The first one clarifies the initial statutory intent to allow admission of foreign workers for temporary or seasonal work based upon the terms of the job offer, so long as the duration of that job offer meets the current regulatory definitions of temporary or seasonal, which is less than 1 year. Now, those of you that have been here for a couple of years may notice that this is a small change from language that I've offered in previous years. This language is not as comprehensive in that it does not change the underlying statute to eliminate entirely the need for the agricultural job to be temporary or seasonal, which is unfortunately previously encountered some opposition at the Rules Committee, with one recent exception. Nevertheless, the proposed language to clarify what it's already on the books would go a long ways in addressing labor needs in all of agriculture by allowing the farmer to set the terms of the job offer, enabling the worker to maintain non-immigrant status and circular migration, so long as the duration of the job does not exceed the duration of temporary or seasonal, as defined in the regulations, if that makes sense. So we're not changing law, we're just changing the ability of the farmer that offers the employment, that allow him to make sure that, or him or her, that the job follows the definition of current law. New House number 2 would block new regulatory requirements that the previous administration finalized as literally as they were packing up their offices late in December of 2024. And it became effective merely 3 days before the inauguration of President Trump. So in this last-minute effort, DHS finalized new regulatory requirements that expanded its authority over labor law, establishing policies that allow H-2A workers to roam around the country without a valid new contract in place, and essentially creating strict liability for growers based on the actions of third parties in a foreign country, all of which would jeopardize the entire H-2A program, which is essential to so many farms in order to stay in business. So I would encourage my colleagues to work with this bipartisan team to build a strong legal workforce and encourage all members to support this amendment. And just a small comment on the observations of Chairman Amodei. I've heard Chairman Cole say many times, we don't authorize in the Appropriations Committee, we appropriate. But I would agree that it is very important for us to engage in this important debate and conversation to build support and momentum so that the authorizing committees, in this particular case, the Judiciary Committee, can feel that urgency and that momentum so that we can actually make important changes to policy and to law. And I think this is an important step for us to do as the Appropriation Committee to weigh in on this important topic. So thank you, Mr. Chairman. I urge support and I yield back.
Thank the gentleman. I think I actually quoted Chairman Simpson, who once told me, we don't authorize on an appropriation bill until we do. That I want to recognize my good friend, the gentlelady from Ohio, for any remarks she has on the en bloc amendment.
Thank you, Mr. Chairman. I just have a clarification because as we began discussing this amendment, there was reference made to rural areas that have seasonal needs for harvesting and so forth. But then it morphed a little bit into circuses and carnivals. And I wanted to get some clarification on what is included because I represent a very large amusement park called Cedar Fair, but it only operates 3/4 of the year or less. How do you look upon parks such as Disney World or Kings Island? There are different water parks in other parts of the country, many of which are seasonal. How do you define, you started out talking about circuses and carnivals. Is there a definition of that?
Gentleman from North Carolina is recognized to answer the gentlelady's question.
Yes, thanks for the question. There are different types of P visas. There are different categories. And depending on the seasonality, if you will, would be the what the applicant would request. I think there's like 6 different variations of a P visa.
So it would not necessarily preclude these organizations, these
No,
businesses?
not necessarily. I would view those, while I'm not an attorney, I would view those as entertainers inside of a bigger organization.
Thank you. And I yield back.
Gentlelady from Maine, Ms. Pingree, is recognized for her comments on the en bloc amendment.
Thank you, Mr. Chair. I just want to thank my colleagues who have been working on some of these H-2B related issues and make a few remarks about how they impact in Maine. First, I just want to say this is the Homeland Appropriations Committee, and we will have a lot of debate today related to immigration issues. And in my opinion, most of them go back to the fact that this Congress has been unwilling during the period of time I've been here to pass comprehensive immigration reform. Let's just get that done. We are going to have endless debate today, and it is all related to the fact that we don't straighten out the situation that goes on in our country. The need for workers, the need to make sure that we have legal processes for people, and the need to make sure that farmers and hospitality industry and everyone else has all the people they need to do the job. I also want to concur, we shouldn't be authorizing on an appropriating committee, but we do when we do. And we all use it when we can because things like this are so vital. And this amendment comes up every year. And I'm always pleased to work with my colleague, Mr. Harris, and so many others, Mr. Cuellar, who also have these concerns. Dutch, who used to be on the committee. If you have any kind of a seasonal industry, you know what we're talking about. And this one also includes some agriculture, which is very much the same. So I remind you all that I represent Maine. This is our summer season. I hope you're all planning your August vacations, your opportunity to eat some lobster, have some wild blueberries, spend a little time on the ocean, and see our wonderful state. If you want, you can come in the winter, where we also have a seasonal industry of skiing and winter sports. So we'd love to have you either time. Tourism is our largest industry, and while we're very proud of our agriculture, fishing, manufacturing, the other things we do, we depend on tourism. And like so many other states, we don't have enough people to do the jobs. Now, it's a common summer job for kids. All my kids worked in the seasonal industry. I've worked in the seasonal industry. We've owned businesses in the seasonal industry. And the challenge is, while people say, oh, what a great summer job for kids, by the time it gets to August, they're back to school, they're back to sports. You can't finish out the season. And we are thrilled that our tourists stay through October or come in even early November now, but we don't have enough people to do the work. And I can list countless employers who come to visit me every year and say, what's going to be the situation? How many workers? Will I be able to get the number of people that I need? I have examples of a family here who had a family-owned seafood restaurant for 17 years. They've been able to run their business, support local fishermen, because they have H-2B workers. Motels, and when they don't have enough people, they close down a wing. They can't be open for the season that they want because they don't have enough people. So without these visas that are so necessary, without these kinds of amendments that we have to sponsor usually every year because we're always at odds with the system, we can't do it. So I just want to support all the people who work on this, but I want to encourage us all to find an ultimate solution so that we're not here every year authorizing on this committee and also dealing with a hodgepodge solution to immigration reform. With that, I'd love to yield the rest of my time to Mr. Cuellar for his thoughts.
Mr. Chairman, I just want to clarify something to Ms. Capter. On the circus part of it, if you look at the section dealing with the P, it deals with mobile entertainment provider, which means a carnival or circus that travels around the United States on a temporary basis or seasonal worker, et cetera. So there is a definition there for the circus worker. So I just wanted to, you asked for a definition, and if you look at the amendment, there is a definition that. With that, I yield back the balance of my time. Thank you, Ms. Pingree.
Thank the gentleman. Gentlelady from Texas, Ms. Escobar, is recognized for her comments on the en bloc amendment.
Thank you, Mr. Chairman. Thank you to the ranking member. And thanks to Chairman Amade and Ranking Member Underwood for their collegiality on this subcommittee. I also want to add my support to this, but really wanted to speak to the overall effort and in a way echoing what Ms. Pingree just mentioned. It's heartening when we are able to work together in a bipartisan way on an issue that has become one of the most toxic issues in America. And I wish we could take a look at the overall issue instead of just the narrow focus on agriculture. I completely agree. I mean, we've got to put food on the table. We need to support our farmers. But if you, like me, have been visited by CEOs and companies across the country, all of the various sectors that need workers, if you, like me, have looked at our census numbers and see that families are not having babies at the same rate that families used to, I mean, my parents had 12 siblings each. I don't know many of us who are having 12 kids anymore. At the same time, we're getting older. And if we want to remain a competitive nation, we need immigration reform. And obviously, we're not here to do immigration reform. We're the Appropriations Committee. I can tell you, having come from the Judiciary Committee, we are pretty far from doing immigration reform in any meaningful way, and that has to change. And it has to change with these bipartisan conversations, with the ability for us to work across the aisle and come up with common sense solutions. I can tell you what doesn't work. Demonizing people doesn't work. Making people fear others doesn't work. What we're seeing today, these quotas of 3,000 apprehensions per day, an arbitrary quota determined by Stephen Miller, and seeing people, hardworking immigrants being chased in agricultural fields, overcrowded detention facilities. Through reconciliation, putting all of that on steroids, using DOD funding to put it even more on steroids, we all need to work together on this issue. If we can come up with narrow, targeted solutions for agriculture, that means we can do this in a broader way. So I rise to urge my colleagues, especially in this markup today, for us to hear one another, not demonize one another, and not demonize the people that this bill will impact. Thank you, Mr. Chairman. I yield back.
Thank the gentlelady. Before I recognize are there any other members who wish to address the en bloc amendment? Seeing none, before I turn to Dr. Harris to close, I feel incumbent to say, as a former chairman of the Rules Committee, those of you that have an interest in this need to be talking to the Committee of Jurisdiction, Judiciary, and need to be talking to the Rules Committee, because they do have the ability to come in and challenge this particular measure. So if you have an interest, don't think we can just solve it here. You've got to go talk to the folks on Judiciary and particularly on the Rules Committee. So just a piece of free advice. With that, I yield to Dr. Harris, 1 minute to close.
Thank you very much, Mr. Chairman. We certainly will be discussing this before this comes before the whole body. And as the chairman of the subcommittee indicates, this is to make sure this discussion occurs and that some movement forward is made, because we're at a critical juncture with our workers in the country. And again, as we begin the process of returning some workers to their homeland, we're going to need some workers to come in under a strictly monitored system, and that's what this amendment does. So I urge a yes vote.
Questions on the amendment? All those in favor say aye. All those opposed say no. The opinion of the chair, the ayes have it, and the amendment is adopted.